Okay, we're on freedom of expression. This is First Amendment, primarily speech, but there's different speech other than talking, like symbolic speech, speech with symbols. I'm on page 95. A democracy depends on the free expression of ideas. Thoughts that are muffled, speech that is forbidden, and meetings that cannot be held are the enemies of the democratic process. Totalitarian governments know this, which is why they go to enormous trouble to limit expression. Americans pride themselves on their free and open society. Freedom of conscience is absolute. Americans can believe what they want. The First Amendment plainly forbids the national government from limiting freedom of expression. That is, the right to say or publish what one believes. Is freedom of expression then like freedom of conscience absolute? Most experts answer no. So you can believe anything, but you can't necessarily say anything. Supreme Court Justice Oliver Wendell Holmes offered a classic example of impermissible speech in 1919. The most stringent protection of free speech would not provide a man in falsely shouting fire in a theater and causing a panic. And I'm having you listen to a podcast that talks about how annoying that people quoting that are. Given that not all speech is permissible, the courts have had to address two questions in deciding where to draw the line separating permissible from impermissible speech. First, can the government censor speech that it thinks will violate the law? Second, what constitutes speech or press within the meaning of the First Amendment, and thus deserves constitutional protection, and what does not? So if it's considered speech under the First Amendment, it deserves protection. The other idea is censorship is the first one here, and you're going to see that. Holding a political rally to attack an opposing candidate's stand receives First Amendment protection. Obscenity and libel and incitements to violence and overthrow of the government do not. But just how do we know, for example, what is obscene? To complicate matters further, certain forms of nonverbal speech, such as picketing, are considered symbolic speech and receive First Amendment protection. Judges also have had to balance freedom of expression against competing values, such as public order, national security, and the right to a fair trial. Then there are questions regarding commercial speech. Does it receive the same protection as religious and political speech? Commercial speech is TV and ads, billboards. Regulating the publicly owned airwaves raises yet another set of difficult questions. That would be radio and TV through the airwaves, not the same as cable or private radio stations, or like Spotify. One controversial freedom of expression issue involves so-called hate speech. Advocates of regulating hate speech forcefully argue that, for example, racial insults like fighting words are undeserving of First Amendment protection because the perpetrator's intent is not to discover the truth or invite dialogue, but to injure the victim. So those are hate speech is when you're trying to injure the victim with your talk, be nasty. Usually racially or anti-LGBT, etc. In contrast, critics of hate speech policy argue that sacrificing free speech rights too high a price to pay to advance the cause of equality. In 1992, the Supreme Court ruled that legislatures and universities may not single out racial, religious, or sexual insults or threats for prosecution as hate speech or bias crimes. Hate speech is protected. Just because somebody doesn't like your racism doesn't mean that it can be prosecuted. Now that's a little different in schools though, because in schools everyone has a right to be educated. So hate speech in the school could cause a disturbance in education, which can really lead to consequences, which is not the same as being charged with a crime or even possibly being sued. There is such a thing as intentional infliction of emotional distress for a lawsuit, but that's really hard to prove. Very hard to prove. So people use this word hate speech a lot and try to argue because they don't know law, I guess. We have to prosecute that. We have to forbid that. No, you can't. Now that again doesn't mean they can't kick you off their platform. Doesn't mean someone can't fire you, but you're not going to be prosecuted for hate speech. In itself, that makes sense. There are other reasons to be prosecuted, but not for that. Prior restraint. In the United States, the First Amendment ensures that even if the government frowns on some material, a person's right to publish it is all but inviolable. They have a right to do it. That is, it ensures that there will not be prior restraint. Government actions that prevent material from being published, or in a word, censorship. A landmark case involving prior restraint, censorship, forbidding government stopping a publishing of something. And remember, it has to be the government. That doesn't mean a newspaper has to post or print what you write. They're a private business. They can do what they want. People get that wrong all the time, especially when we start talking about like Twitter. Twitter is not the government. They can censor you. Censorship is specifically in regards to the government entity. A landmark case involving prior restraint is Near v. Minnesota. Note the date, 1931. A blunt newspaper editor called local officials a string of names, including grafters and Jewish gangsters. The state closed down his business, preventing him from publishing. But the Supreme Court ordered the paper reopened. Of course, the newspaper editor could later be punished for violating a law or someone's rights, such as libel, after publication. So there are other ways, but if someone wants to be anti-Semite in their newspaper, that is, the government can't prevent them from writing it. The extent of an individual or group's freedom from prior restraint does depend, in part, however, on what that individual or group is. Expressions of students in public school may be limited more than those of adults in other settings. In 1988, the Supreme Court ruled that a high school newspaper was not a public forum and could be regulated in any reasonable manner by school officials. In 2007, the court held that the special characteristics of the school environment and the governmental interest in stopping student drug abuse allow schools to restrict student expressions that they reasonably regard as promoting such abuse. We can make you change if you have an alcoholic beverage or beer, which is an alcoholic beverage, on your t-shirt because you just went to Mexico or something and that's what you brought back. We can restrict that. That is not freedom of speech, not in the school. Now, once you leave the school and you're off of school property, but if you're at a school event even, we can restrict that. Cigarettes are another one. And anything with alcohol, illegal drugs, legal drugs that are prohibited to those under 21. You do not have freedom of speech. The court has been very clear on that. In the name of national security, the Supreme Court has also upheld restrictions on the right to publish. Wartime often brings widely supported censorship to protect classified information. Few want to publish troop movement plans during a war. The constitutional restrictions have not been limited to wartime censorship. Former CIA officials have to meet their contractual obligations to submit books about their work to the agency for censorship, even though the books reveal no classified information. So when people, and this happened under one of Trump's former, I don't know if it was an assistant or something. Oh, I know who it was. It was the John Bolton, who worked in national security position under Trump. And there was an argument whether or not he had published classified information. I think he was cleared he didn't, but I don't know the details. Point being, though, is when he wrote his book, he has to go through procedures, which is censorship or prior restraint because of national security. In recent years, WikiLeaks has published hundreds of thousands of classified government documents covering a wide range of foreign policy issues. Someone leaked it, or they got into they hacked into systems and they leaked it. The U.S. Department of Justice has opened a criminal probe of WikiLeaks founder Julian Assange. That's a whole story into itself, because he's also the one that the Russians hacked the Democrats in the 2016 election. Julian Assange, the Russian hackers gave the info to Julian Assange. He consequently published it. There is allegations that people like Roger Stone, who worked for Trump or worked with Trump, I don't know if he was paid or not, had direct contact with Julian Assange and helped time these leaks, these DNC, Democratic National Committee emails and such, in order to affect the campaign. That's what the whole Russia probe, or part of the Russian probe that surrounded that 2016 election, was about. But this one, Edward Snowden, on the other hand, went a different way. The government is similarly pursuing Edward Snowden for divulging documents related to electronic surveillance. Edward Snowden is now in Russia because he doesn't want to be prosecuted by the U.S. He worked for a private contracted by the federal government to do intelligence. And there are people in the U.S. I don't know anybody in the U.S. who's supporting Julian Assange and what WikiLeaks did, but there are people in the U.S. who do or did. I don't hear much about it anymore, what Snowden did. They think his releasing of the spying that was going on by the national security of the U.S., they thought that was a heroic act. However, it's also most likely, allegedly, an illegal act, I would assume. But he has not been prosecuted yet because he's in Russia. Nevertheless, the courts are reluctant to issue injunctions. An injunction is when you tell someone to stop doing something. So if we put an injunction on your neighbor to stop walking through your yard, or it's usually, I think, maybe a company, you can no longer dump that into the river. It's stopping a company or a person from doing something. So versus a fine where if you're suing or something, there's money. Courts are reluctant to issue injunctions prohibiting the publication of material, even on the grounds of national security. The most famous case regarding prior restraint in national security involves stolen papers concerning the war in Vietnam. And that is the Pentagon Papers in New York Times. And that's a case that you're going to be looking at in class. It is a required case for AP College Board. Okay, in wartime and peacetime, considerable conflict has arisen over the trade-off between free speech and the need for public order. During World War I, Charles Schenck, the secretary of the American Socialist Party, distributed thousands of leaflets urging young men to resist the draft. Schenck was convicted of impeding the war effort. In Schenck v. U.S., the court upheld his conviction. Justice Holmes declared that government could limit speech if it provokes a clear and present danger of substantive evils. But only when such danger exists can government restrain speech. It is difficult to say, of course, when speech becomes dangerous rather than simply inconvenient for the government. The courts confronted the issue of free speech and public order in the late 40s and early 50s when there was widespread fear that communists had infiltrated the government. American anti-communism was a powerful force, and the national government was determined to jail the leaders of the Communist Party. On the basis of the Smith Act in 1940, which forbade advocating the violent overthrow of the American government, Senator Joseph McCarthy and others in Congress persecuted people whom they thought were subversive. In Dennis v. U.S. 51, the Supreme Court upheld prison sentences for several Communist Party leaders for conspiring to advocate the violent overthrow of the government, even in the absence of evidence that they actually urged people to commit specific acts of violence. Although the activities of this tiny, unpopular group resembled yelling fire, not necessarily, in an empty theater rather than a crowded one, the court ruled that a communist takeover was so grave a danger that the government could squelch the threat. Thus, the court concluded that protecting national security outweighed First Amendment rights. Soon, the political climate changed, however. And the court narrowed the interpretation of the Smith Act, making it more difficult to prosecute dissenters. In later years, the court has found that it is permissible to advocate the violent overthrow of the government in the abstract, but not actually to incite anyone to imminent lawless action. So if you're inciting violence, you're inciting an attempt of overthrowing the government, that is not protected. But the abstract argument, the abstract statement that is protected. Of course, we can debate the lines for that. The 1960s brought waves of protest over political, economic, racial, and social issues, and especially the Vietnam War. Many people in more recent times have engaged in public demonstrations, such as the opposing of the war in Iraq or protesting against Wall Street. Courts have been quite supportive of the right to protest, pass out leaflets, or gather signatures on petitions, as long as it is done in public places. People may even distribute campaign literature anonymously. First Amendment free speech guarantees do not apply when a person is on private property. You don't get to go into McDonald's because that's private property. It serves the public, but it's owned by a private either a person or corporation. And so you can't go into a McDonald's and start protesting and call that free speech. They tell you to leave and you don't, you are now trespassing. And you're also seeing this with, I don't know how many years people will listen to this, but these mask issues, when they tell you, if they want you to wear a mask and they're following the law, or it's their own choice, and you don't wear the mask, and you argue freedoms and First Amendment and my rights, and they tell you to leave, and you don't leave, you are now trespassing. It's different on government property or true public property, which would be like the streets. Well, actually, you're getting in trouble in the streets too, but the sidewalks. Go out to the sidewalk, protest there. Although a state may include within its own free speech guarantee politicking in shopping centers. I don't know how many actually do that. I guess he brought up California. I don't even know if it's true anymore. But remember, the states can always give you more rights, not less. But as far as the Constitution, interpretation of the Constitution is concerned, your free speech is not protected on private property. You can't come to my house, start yelling at me. Well, you can, but I'm calling the cops. Moreover, cities cannot bar residents from posting signs on their own property. And they cannot impose more stringent restrictions on signs directing the public to the meaning of a nonprofit group than on signs conveying other messages. So I wonder, it's different if you put a political sign up in front of your yard versus putting a sign to run a business. Businesses are regulated. Political speech, they work hard not to regulate that. So even though you might live in a neighborhood with a association that says no signs except 30 days prior, that's probably going to be, the courts are going to rule in your favor that you have a right to a political sign on your yard. You might not have a right to other signs on your yard, though. Okay, obscenity. Obscenity is one of the more perplexing free speech issues. In 1957, in Roth v. U.S., the Supreme Court held that obscenity is not within the area of constitutionally protected speech or press. Deciding what is obscene, however, has never been an easy matter. So the court has to make decisions over the decades, what is protected speech. They start out with everything is protected. All speech is protected. Then they move to pull items off that list. And once they pull the item off that list, it is no longer protected speech. Obscenity has always existed. Obscene is sexual, by the way. It is not the violence. Violence has yet to be pulled off the list of protected speech. So you can't censor violence the way you can censor, when I say you, I mean the government. The government can censor nudity and obscenity, but it can't censor violence in like a movie. because it's about being protected versus unprotected. And the court makes a decision on whether or not something is unprotected speech. The bigger issue then is, well, how do we define obscenity? And with the time of the internet, as it is now, it used to be that a community could define it and say, we don't want that here. We don't want that adult bookstore here. We don't want that movie shown here. We don't want that music group, band in our community. But with the internet, you bypass community. It goes right to the person's personal home. So little different. We're still see where the future decides. But as you need to know, though, is obscenity is not protected speech. Okay, obviously, they say obviously, public standards vary from time to time, place to place, and person to person. Many of today's music videos would have been banned only a few decades ago. That is very true. What Madonna played in, and what wasn't played that Madonna did in like 91, 92, pretty tame compared to what people have access to now. What might be acceptable in Manhattan's Greenwich Village would shock residents of some other areas of the country. I think that's a little unfair. I don't know if it's shock, but maybe they wouldn't appreciate it. Works that some people call obscene might be good entertainment or even great art to others. At one time or another, the works of Aristophanes, Mark Twain, and even the Tarzan stories by Edgar Rice Burroughs were banned. The state of Georgia banned the acclaimed film Carnal Knowledge. The Supreme Court struck down the ban in 1974. I have no idea what that's about and why they struck it down. It's interesting. Might have to look that one up. The court tried to clarify its doctrine by spelling out what could be classified as obscene and thus outside First Amendment protection in the 1973 case of Miller v. California. Chief Justice Berger wrote that a work was obscene under the following circumstances. So one of the common actions the court does is they create tests, T-E-S-T, tests, or a test to determine so that there's guidance by maybe the public school, local governments, state governments, whomever, to determine whether or not something is protected or not protected. The tests are found in 14th Amendment Equal Protection Clause. We're going to talk about that. The Lemon case for religion and First Amendment religion issues. Often, though, a test is the guidance. Got it? So here's one test. Looking at the work taken as a whole, this is how you know it's obscene. Appealed to a prurient, hope I'm saying that right, interest in sex. The work showed patently offensive sexual conduct that was specifically defined by an obscenity law. The work taken as a whole lacked, quote, serious literary, artistic, political, or scientific value. Now, who decides all of this? That's why. So now remember, this is back in 1973. Keep that in mind. Decisions regarding whether material is obscene, said the court, should be based on how average people, I actually think a better word is reasonable. Average, I don't know if that's a good, usually it's more a reasonable person test. What would a reasonable person think? Apply the contemporary standards of local, not national, communities. The court did provide a few plain examples of what sort of material might fall within this definition of obscenity. Among these examples were patently offensive representations of ultimate sexual acts, and you can read the rest of that because I'm not going to read that. The problem remains in determining what is lewd or offensive. The challenge of defining obscenity makes it difficult to obtain an obscenity conviction. So does the absence of a nationwide consensus that offensive material should be banned, at least not when it is restricted to adults. In many communities, the laws on pornography are lenient. Prosecutors know that they may not get a jury to convict, even when the disputed material is obscene, as defined by Miller. Thus, obscene material is widely available both on and offline. Remember, when it's not constitutionally protected, that means the government, in this case, local government, can make laws and enforce laws against it. If it was protected speech, the local government would not have any say. They wouldn't be able to. So obscene, whatever obscene might mean, government, whether it be the local, Fruitport, Grand Rapids, the state of Michigan, the federal, although I don't know how much the federal government makes laws on this, can make laws against obscene speech. It's figuring out what obscene means is difficult. Despite the court's best efforts to define obscenity and determine when it can be banned, state and local governments continue to struggle with the application of these rulings. In one famous case, a small New Jersey town tried to get rid of a nude dancing parlor by using its zoning power to ban all live entertainment. The court held that the measure was too broad, restricting too much expression, and was thus unlawful. However, the court has upheld laws specifically banning nude dancing when their effect on overall expression was minimal. I don't know what any of that means. They talked about drive-ins here. And you look it up. Regulations such as rating systems for movies and television that are aimed at keeping obscene material away from the young. Remember, obscene is only sexual. We're not talking violence. Who are considered more vulnerable to harmful influences have wide public support. Courts have consistently ruled that states may protect children from obscenity. The public and the courts also strongly support laws designed to protect the young from being exploited in pornography. It is a violation of federal law to send or receive sexually explicit photographs of children through the mail or over the internet. And in 1990, the Supreme Court upheld Ohio's law forbidding the possession of child pornography. It is, hopefully goes without saying, not constitutionally protected. It is not, child pornography is not protected speech. Also want to point out here that the rating systems are actually not law, especially with violence. There are rules about obscenity, but violence is still protected speech in movies and such. There's not been a ruling yet to forbid it because most laws against violence in film are too vague. And the courts strike them down. For example, if you make a, not hurting animals, video that shows the hurting of animals. Well, then what about if a hunter videotapes his kill or her kill and dissection of the deer? It's too broad. It's too difficult to make these laws without enveloping things that would be considered acceptable. So the court has stayed away from it. They haven't moved violence from protected to unprotected. So when you look at these rating systems, like R-rated movies, PG-13, or those parental black parental, I don't even remember what it was, explicit language on back in the days when we bought CDs. Those are actually by choice. The businesses are choosing to keep you from seeing that movie because they think it's in their best business interest. So you are trespassing if you go into an R-rated movie under 17 without an adult. You're not breaking a law. You're breaking a business practice. And they do that again to try to, they don't want to get anybody too upset with them, which is different than what is, I don't even know if you know what this means, X-rated movies. Adult obscene material, the government can restrict. I've said this multiple times when I've been reading this. Hopefully you get it. Go from there. Advances in technology have created a new wrinkle in the obscenity issue. The internet and the World Wide Web make it easier to distribute obscene material rapidly, and a number of online information services have taken advantage of this opportunity. In 1996, Congress passed the Communications Decency Act, banning obscene material online and criminalizing electronic transmission of indecent speech or images to anyone under 18. This law made no exception for material that had serious literary, artistic, political, or scientific merit as outlined in Miller. In 1997, the court overturned it as being overly broad and vague and thus a violation of free speech. 2002, the court overturned a law banning virtual child pornography on similar grounds. Yeah, you should, that one's, you have to look that one up. I mean, maybe not, but okay. It was too vague. We'll go with that. In 1999, however, the court upheld prohibitions on obscene email and faxes. In 2011, the court ruled that a California law banning the sale or rental of violent video games to minors violated the First Amendment because the games communicate ideas. Depictions of violence, the court added, have never been subject to government regulation and thus do not qualify for the same exceptional treatment afforded to obscene material. The California law imposed a restriction on the content of protected speech and was invalid because the state could not show that it served a compelling government interest and was narrowly tailored to serve that interest. Again, too vague, too broad, too many issues with it, not a well-written law would be their argument. So in this one, this was a big deal in 2011. This was the chance for the court to pull, remember, all speech is protected until the court decides it's not. The court decided decades ago that obscene material is not protected, especially when it comes to children, because the government has an interest in protecting children. Well, then they argue, what about violence? In this case, violent video games. Don't we have to protect the children? Because it was only about minors, selling to minors. And they thought it was a poorly written law, and they weren't willing to move violence from protected speech, because all is protected until not, to that new not protected. They didn't go there. And as far as I know, they never have. So violence still falls under protected speech because it's never been moved to not protected. I will stop at this one.